I'm joined today by Greg Dunn, the lead counsel in two Section 74 applications in Alberta, to talk about a decision that came today where a judge found essentially a court win in favor of some Section 74 applicants, and it's one of the rare wins for Canadian gun owners in this matter. Hi, Greg Dunn. Thank you for joining me.
Hi, Nicholas. How are you?
Really good, really good. And congratulations again for this win. Can you just lay out for us what are the key points of what happened today in Judge Poolman's decision?
Well, I'll give you a bit of background with respect to the case. I can indicate that as probably many of your subscribers to your blog would know, is when the recent order in council, well, not recent now, but the order in council came up with respect to the reclassification of large amounts of what were previously unrestricted and restricted firearms to prohibited under the Trudeau Liberal government. Notices were sent out to holders of registration certificates of what were then restricted firearms. And these notices essentially said that, look, your firearm has been reclassified. It's been reclassified to prohibited. And as such, your registration certificates are deemed to be nullified or invalid. And as many of your listeners may know, is that ordinarily when you have a registration certificate or a license and the registrar or the government decides to cancel it, they go through a process called revocation, and they generally send you a notice in the mail, and you have a right to challenge that revocation under Section 74 of the Firearms Act. So you get your day in court, in other words, and you get due process. This process that the government endeavored to follow was to circumvent everyone's constitutional and judicial rights to challenge the cancellation of their certificates. And the way they did it is they simply argued, they said, we're not revoking it. We're simply saying that certificates are nullified. They no longer exist. And basically what they did is they basically truncated and eliminated everyone's right of appeal. So my two clients and another of other self-representative accused filed Section 74 references with the provincial court. And this was done across the country, with many gun owners and in many different jurisdictions. And the only decision, or one of the only decisions that came down in favor of having a Section 74 reference was a provincial court judge here in Calgary named Judge Fracham. Most other jurisdictions declined to hear them, and so basically extinguished everyone's appeal rights. But Judge Fracham said, no, I believe that what ultimately the government has tried to do is they've tried to basically revoke people's certificates without using the word revocation, and they've tried to end run the revocation procedure. And the AG or the government didn't like that decision of provincial court, so they appealed it. And they appealed it up to Queen's Bench. And the decision at Queen's Bench, which is now the highest court to consider this issue, was that no, indeed, Judge Fracham was not incorrect in deciding that this was in fact a revocation, and now has remanded the cases back down to Judge Fracham to hear the revocation hearing.
And so this is, and I'm getting an appreciation that this is incredibly technical stuff, but just also to recap, this is what the government did on May 1st, 2020, in revoking the firearm registration certificates for our previously restricted firearms. It essentially put more than 70,000 people outside the law. It made us criminals because we were now in possession. So it's very technical and legalistic, but it's also has very real world consequences for the 70,000 people like me who all of a sudden are criminals now under amnesty. And we're dealing with some big stuff like this is criminal law, and we have another angle, which is the Criminal Code and Firearms Act, which are in play here, are federal, but the Section 74 application is a Section 74 of the Firearms Act, but it's an application to go to a provincial court. So we've got two levels of government here.
Well, it is fairly complicated. I think the main point to hit home to your listeners is that these notices that were sent out that said we are nullifying your certificate, you do not have a right of appeal, are incorrect. Essentially, they are attempting to revoke your certificate, and indeed, you do have a right of appeal. So all of the individuals that were previously under the impression they didn't have right to a Section 74 reference in order to challenge potentially the revocation of their certificate, this court has said those individuals do have a right of appeal, and that appeal is to be held in provincial court.
And that applies to, so you're representing two of the applicants out of 9 in this, I'm going to call it this package, but there's a lot of other people in Alberta and a lot of other people outside Alberta throughout the country. Judge Poolman's decision today applies only to the 9 in this package?
Well, it applies directly to the 9 in this package in Alberta, which are going to be remanded back to provincial court for a revocation hearing. It also creates binding authority on the provincial court judges here in Alberta that indeed the someone who files a Section 74 appeal due to one of these nullification notices has indeed has a right of appeal. So now the question is what about those people that have already had these notices sent to them and they haven't filed the notice of appeal within the statutory time frame that's required? What happens to all those individuals? And, the law is unclear on that, but I would suggest that in view of this authority, that anybody that has in the past received a nullification notice to consider filing a Section 74 appeal and, having their appeal heard in provincial court.
So that's amazing. Am I understanding right? So anybody in Alberta who received one of those nullification notices should apply?
Well, I'm not saying that they should apply, but if they're interested, it gives them a legal foothold to apply.
It gives them a legal foothold to apply. Okay.
Now, whether this would be adopted in British Columbia or whether it would be adopted in Ontario, of course, Alberta case law is not binding on the rest of the country, although it is persuasive and it does have still judicial merit that a higher court decision made this particular finding in Alberta. Other courts in other jurisdictions may look at it and reconsider their position. But right now, this is Alberta law.
Got it. Okay, so this is really important for applicants in Alberta and informative and influential potentially for anyone concerned by the nullification notices outside Canada, outside Alberta, throughout Canada. One other thing in looking at the judge's decision. So I'm not a lawyer. This is my first time looking at this type of decision. Is it accurate to say that the Registrar of Firearms broke the law based on this? Is that a valid interpretation of this judge's decision?
No, I don't think you want to. I don't think you want to sensationalize it and take it, to that level. I think we're all better served as of understating something rather than overstating it. I would simply say that the registrar, what the court said in provincial court, and what Judge Poolmans said at Queen's Bench, is that when the registrar set out these nullification notices, in effect, what he was sending out was registration notices. okay? And the registrar's understanding that the certificates were just nullified and a formal revocation process didn't have to be followed, the courts have found that he was in error with respect to particular finding. So I wouldn't say so much that the registrar broke the law, but simply didn't follow the law in terms of attempting to properly revoke certificates of people who have these firearms that have potentially been reclassified.
Okay. Because there are, again, just to restate, I haven't seen many of these decisions. I don't know if this is a dime a dozen like this, or if it's a one-off. But it occurred to me that as if the judge took several paragraphs, several pages to say, here's how the law works. That's not what happened. The importance of the rule of law and creating a stable, predictable framework for Canadian citizens, and that's not what's happening here. I'm wondering if there's anything to read between the lines in terms of the amount of time the judge devoted to explaining how the rule of law works.
Well, and you're right. So the judge spent an inordinate amount of the decision talking about rule of law and how governments assume authority over the citizenry, and he very clearly says that in order to do something or to affect something, you have to have a positive. The government needs to point to a positive law or legislation or regulation or valid rule which authorizes them to act in a certain fashion. And the government can't simply make up technical terms willy-nilly and decide, hey, we're not revoking your certificate, but now they're nullified. Well, there's nothing in the criminal code that talks about nullification. There's nothing in the Firearm Act that talks about nullification. So the statutory scheme that has been set out for us by Parliament in the Firearms Act, in the criminal code, talks about revocation, not nullification. And so what the judge said very clearly, the learned justice said very clearly, is that you have a procedure that's to be followed, follow the procedure. Now, that doesn't mean ultimately, Nicholas, that the government cannot revoke these certificates. It doesn't mean that there's not a process to revoke them. It simply means that if the government is to revoke them, they have to follow the proper process.
Right, and also just to be clear, like this is not saying today's decision does not by any means predict an outcome one way or the other. It just says that they have a right to be heard in court based on this question. It's giving them their day in court. Yeah. And what occurs to me also as an advocate and as an owner targeted by the mass criminalization order of May 1st, that if they claim revoked my registration certificate, is people across the country have applied for Section 74 hearings. Some judges have said, no, there's no jurisdiction. Other judges have said yes. This to me says there's a real legal question here that needs some clarity and certainty, because we have different interpretations. That's not how the law is supposed to work, right? It's supposed to be clear and predictable and certain. How do we make sense of this, or how do we, as an owner targeted by this, with this confusion, I guess, what can we do?
Well, I mean, I think ultimately you need to look at Canada as it is can be a little bit confusing because, of course, criminal law is legislated by the federal government and is enumerated under federal heads of power. However, the administration of justice, the court system, is a provincial enumerated head of power. So often federal law, which is passed in statute by Parliament in Ottawa, is interpreted differently in different provinces. And you'll see that very often, for example, on, trafficking, drug trafficking sentencing ranges can vary from province to province. There's many things actually over at Canada in which it'll be quite different from British Columbia to Alberta to Ontario. So right now, there's nothing to say that I can say to someone in Ontario, hey, you guys are free and clear. You're certainly not, because they are going to be ultimately bound by Ontario courts and Ontario decisions. What I can say is it does bring the matter to light that now we have an Alberta Queen's Bench decision, which is Superior Court, with that has made a decision that is in contravention of and inconsistent with other areas of the province. So what does that mean overall? Well, it means that people in Alberta are in a better position with respect to firearms, and it means that the government may take steps to clarify or get some consistency in the case law across the province, which, there is potential for an appeal. And that's what happens, is if there's inconsistencies between jurisdictions, then ultimately the appeal goes up to the Supreme Court of Canada, and they make the decision for everybody.
And have you, in your practice, have you ever heard of, or as a student heard of something, a decision directly affecting more than 70,000 people, where different judges throughout the country have given different interpretations on something like this? Like, I'm wondering, is this a pretty rare set of circumstances, or is this this is just how law works in democracy?
I would say that ultimately judges are people, and people are a product in their environment. And someone who comes from Metro Toronto is going to have a much different sentiment towards firearms than someone that comes from High River, Alberta. And so does that mean that implicitly means they're going to make different decisions on this particular issue? It doesn't. It doesn't mean they're going to make different decisions. But remember that judges make decisions through their own personal lenses, their own political viewpoints, their own circumstances, and it can color the way they look at arguments. So in this case, sometimes, yes, legal issues get filtered through those lenses, and you have slightly different decisions that come out in different jurisdictions. Now, really, if we were all robots and we were all programmed the same way and we had all the same inputs and outputs, the decisions should be the same. But that's not how law works. And unfortunately, it's an imperfect system. It's the best system we have, but it does have some degree of human frailty that attaches to it.
It does. As one of the concerned people in this, the mass criminalization of May 1st, 2020, my personal opinion is that the government and possibly the RCMP were acting in bad faith, but that's I guess beyond the courts. What also strikes me though is that the government makes the claim that, this is all about public safety. And in reading the several decisions on the Section 74 applications, I'm seeing what must be hundreds and hundreds of court hours for justices and clerk staff and other stuff that has nothing to do with public safety. So it's almost like this whole public safety thing is some kind of pretense. There's nothing to do with public safety in any of these revocation or nullification notices.
Yeah, I mean, that's kind of more of a political debate, and being an advocate for gun owners, I don't necessarily want to delve too much into the rabbit hole of politicizing the issue. I think what's important for us, as defense lawyers or as criminal defense lawyers on this, is that ultimately what Parliament decides, we have to respect. And I can tell you that I am a gun owner. I believe strongly in the gun rights of law-abiding gun owners. But outside of that, I think what's more important for us to keep in mind is that the rule of law is followed in whatever decisions are made. And, Nicholas, we live in a precarious time in which we've seen fundamental freedoms that have been, really stripped away across the nation in the name of public safety. And I think for many of us, in that work as advocates or work as lawyers, it is concerning to see that the card played of public safety often trumps individual freedoms and liberties. And we all know it's a balance. And there has to be public safety, but it can't go so far as to fundamentally change the nature of our democracy into one in which we start to be no different than countries which are under totalitarian rulers and dictators and whatnot. So in terms of public safety, yeah, it's always the trump card that's often played by individuals making these kind of laws, and it's up to advocates, it's up to defense lawyers, it's up to litigators, and up to the citizens to push back on that. And ultimately, I think this decision is not striking down the Order in Council, reclassifying these firearms. It's not entrenching in our Charter of Rights and Freedoms something similar to the Second Amendment that the United States has. But it's one small step, and it's one small battle that we have won to preserve the freedoms of Albertans here, and hopefully ultimately Canadians as well.
And I think if you're calling it a small step, I think it's a small step that maybe the symbolism is quite big from my view, at least, because at least these applicants are still in the fight, and I say it's a very much a David and Goliath story. So they're still in the fight, which is good. They're going to have some due process. They're going to get their day in court, which I think is significant. And it's also from the get-go, the RCMP registrar and the government of Canada have been making a certain set of claim about what happened on May 1st, and some judges are disagreeing with that claim. So it's a little bit what am I trying to say here? It's small perhaps, but significant, at least procedurally, maybe also in terms of principle. What happens next in terms of the courts? I guess there will be scheduled. I guess it goes back to Judge Fradsham, so he will schedule a Section 74 hearing.
Yeah, that's correct. So we'll ultimately there'll be a 30-day appeal period, and we'll see what the AG wants to do, whether they want to appeal this up to the Court of Appeal here in Alberta, or whether they'll let it lie, and we'll go back. If they do let it lie, we'll go back and have the Section 74 references back in provincial court.
Okay, so that's and could this could depend? I'm assuming that whichever side loses, it's just going to keep going higher. Could this go to the Supreme Court?
I mean, it's a possibility. It could, but we'll see what happens. I mean, we'll see where the inertia of it goes. I don't want to predict whether. I mean, it is something that certainly could go up to the Supreme Court because there are some interesting issues of law that were determined by Justice Poolman. But I will tell you, his decision is, from an academic and analytical perspective, is very good. And I guess anything's possible, but I really think that the Court of Appeal would have a hard time finding that he made any error in law with respect to the decision that I've read to date.
And again, based on the decision you've read today and the bigger issues involved, could you give us some context on how is this kind of stuff? Is this type of a decision usual or unusual? Is this what you deal with every day? Is there something that's a little bit out of the ordinary here?
I don't know. I mean, I don't think so. I think it's an unusual argument. It's an interesting argument. It's a relatively it's not something that you see every day in the courts. It's likely not something that he's seen every day, or even Judge Fradsham has seen every day. So no, it's not something that's quite usually seen in the courts. It's a unique point of law and a fine point of law. I mean, I don't know if I can, we see all sorts of things in court. So judges are always coming up against, novel arguments, and often those arguments, become novel because of the special fact scenarios of each of the individuals involved. But I wouldn't say that it's an unusual argument, but I certainly wouldn't say it was something that the courts would see every day.
And is it got that? And is it common? I guess I'm also thinking of the more than 70,000 people who are directly targeted by these quote unquote nullifications. Is that frequent, where you have a couple hundred people applying to a court on an issue that actually affects tens of thousands of more people?
Well, I don't really know how to answer that. I mean, often there's an old saying. They say that the freedoms and liberties that we all enjoy often come on the backs of criminals. And it's often the case where the few plow the road for the many. And in this case, my two clients, Mr. Stark and Mr. Dolan, have decided to put their financial, their financial back into fighting the revocations, and ultimately them as well as these other, courageous self-represented litigants are plowing the road for the many. And that's just kind of how the criminal justice system works. So the many will benefit from, what they've done here today.
And certainly I consider myself, like I tip my hat. I really recognize that they went ahead. I tried a Section 74 application here in Ontario, and the court clerk wouldn't even send me the form. So where they are now, I really applaud them. And just, is there any way to support them financially? Are they doing a GoFundMe, or would they welcome financial support?
I'm not sure. They haven't asked or reached out to anyone at this moment. I mean, obviously, if this is something that goes to a higher court, to the Alberta Court of Appeal, and ultimately to the Supreme Court of Canada, then I think it's certainly something that, gun owners might want to look at. And, we're all, everyone is stronger when you stick together. And, so often if it was a case that ended up marshaling an enormous amount of resources, and certainly those higher courts and the proceedings are inherently exorbitant in terms of cost, then that's something that I think that they would likely look at. But at this juncture, they've taken it upon themselves and are carrying the load.
They're carrying the load, and I really do hope that other people apply for a Section 74 hearing whichever province or territory they're in, and I'll have links on that. Is there anything else to add for today from your end?
No, Nicholas, I think that's it. I think ultimately the moral of the story is that I think gun owners are a segment of the population in which we're used to being maligned and marginalized and essentially not given a lot of heed with respect to our civil liberties. And ultimately, we can lie down and allow the powers that be to take our freedoms and to take our property, or we can fight. And ultimately, if you fight, you take a risk that you may lose, but you may also win. And that's what Mr. Dolan and Mr. Stark did, is they took that risk and they won. And it may be a small victory and it may be a Pyrrhic victory at the end of the day, but those doors have not yet closed. So I would just encourage everyone to take a stand.
Yeah, and I absolutely beautifully put. And I'm inspired by their action and by today's win. Greg Dunn, thank you very much for speaking with me at TheGunBlog.ca today and discussing this case and helping me and my listeners understand it.
Thanks, Nicholas. Thanks for having me.